Issue. Under additional terms and conditions, the contract provided in handwritten language that the earnest money became non-refundable or hard after the 10-day inspection period. All inspections were completed, and the seller and the buyer agreed on the repairs to be done by the seller. Several days later, the lender's appraisal came in below the sales price. The buyer properly canceled the contract for the low appraisal within 5 days, as provided in the appraisal contingency section of the AAR contract. Is the buyer entitled to the earnest money? No. If the seller and buyer agreed that the earnest money would be non-refundable after the 10-day inspection period, the earnest money is generally only refundable to the buyer if the seller breaches the contract. Therefore, although normally the buyer would be entitled to the earnest money for a failed contingency such as the appraisal contingency or the loan contingency, the seller is entitled to the earnest money if the contract provides that the earnest money is non-refundable after the 10-day inspection period. Facts. Buyer submitted an offer to the seller, which included a buyer contingency addendum. The seller wants to counter the buyer and reject the buyer contingency addendum. Should the seller initial the purchase contract and the buyer contingency addendum and return them both with his counter offer? No. The seller is required to initial each page of the purchase contract, which indicates the seller reviewed all of the pages. However, the buyer contingency addendum is not part of the purchase contract unless all parties agree to the terms. Here, because the seller does not want to accept the buyer contingency addendum, the seller should not sign the addendum, nor should it be returned with the purchase contract counter offer. If seller is countering buyer's offer, the seller should indicate on line 467 of the contract that a counter offer is attached. Otherwise, seller should check the box on line 473 of the contract, indicating seller is rejecting buyer's offer. Regarding lines in 1F, where additional addenda is included to go with the contract, on the counter it should state in the counter that no buyer contingency addendum will be part of the contract. Issue. The buyer wants to purchase the seller's home, but the seller has not yet completed the construction of the well, which will deliver water to the home. The buyer does not want to close the transaction until the well is completed. Can the seller and the buyer agree in the purchase contract to close the transaction only when the seller has completed the well? Yes. Although a specific closing date should be used, a court will enforce a contract with a closing date that is reasonably ascertainable. Therefore, the seller is required to complete the construction of the well within a reasonable time, and, upon such completion, the seller and the buyer are required to close the transaction. If the seller does not complete the construction of the well within a reasonable time, the buyer is entitled to either cancel the contract or sue the seller for specific performance and damages for the breach of the contract by the seller. The buyer will need the testimony of expert witnesses such as hydrologists, engineers, and contractors to determine a reasonable time for the completion of the well. Note: the buyer should provide in the contract for a daily penalty to be paid or the right to cancel the contract if the seller does not complete the construction of the well by a specific date. Facts. A buyer submits an offer to the seller. On line 17 of the contract, the buyer indicates earnest money funds will be provided by a wire transfer. After 2 days, the seller issues a cure period notice because the wire transfer has not been received. The buyer then notifies the seller that the wire is coming from another country. Therefore, it will take more than 2 days for the wire transfer to be completed. May the seller issue a cure notice? Yes. In this instance, the seller may deliver a cure period notice to the buyer. The February 2017 contract allows a buyer to provide earnest money in the form of wired funds. If a buyer cannot initiate the wire transfer upon acceptance, as the contract calls for, then the buyer should indicate under what terms the wire transfer shall occur on page 1 of the contract. Example: buyer shall wire funds to escrow within 2 business days. Facts: Wednesday was the close of escrow date. The buyer did not close escrow. Thursday, the listing agent delivered a cure notice to the title company and to the buyer's lender. The listing agent did not send a copy of the cure notice to the buyer's agent. Did the buyer receive a valid cure notice? No. Pursuant to Section 7A of the Residential Resale Real Estate Purchase Contract, if a party fails to comply with any provision of this contract, the other party shall deliver a notice to the non-complying party specifying the non-compliance. Because neither the buyer nor the buyer's agent received a copy of the cure notice, the buyer has not been given a valid cure notice. The listing agent should immediately provide a cure notice to the buyer's agent. A buyer and seller entered into a contract wherein the buyer agreed to release the $1,000 earnest money after the inspection period to the seller. Thereafter, the buyer decided to cancel. Can the seller still pursue legal remedies against the buyer if the seller already has the buyer's earnest money? No. Pursuant to Section 7B of the Residential Resale Real Estate Purchase Contract, in the event of buyer's breach, the seller may, at seller's option, accept the earnest money as seller's sole right to damages. Because the seller has already claimed the buyer's earnest money, the seller will not be able to pursue other legal remedies for the buyer's breach. Facts. During a transaction, a listing agent sent an image of a cure period notice via text message to the buyer's agent. Can a cure notice be provided by text message? No. Section 8M of the Residential Resale Real Estate Purchase Contract states, unless otherwise provided, delivery of all notices and documentation required or permitted hereunder shall be in writing and deemed delivered and received when I. Hand-delivered. I. Sent via facsimile transmission. Hi. Sent via electronic mail, if email addresses are provided herein. Or IV. Sent by recognized overnight courier service. As such, the listing agent did not deliver the cure period notice properly. The listing agent should proceed with sending the cure notice again via one of the options listed above. Facts. During a transaction, a listing agent sent an image of a cure period notice via text message to the buyer's agent. Can a cure notice be provided by text message? No. The Residential Resale Real Estate Purchase Contract states, unless otherwise provided, delivery of all notices and documentation required or permitted hereunder shall be in writing and deemed delivered and received when I. Hand-delivered. E1. Sent via facsimile transmission. E1. Sent via electronic mail, if email addresses are provided herein. Or IV. Sent by recognized overnight courier service. As such, the listing agent did not deliver the cure period notice properly. The listing agent should proceed with sending the cure notice again via one of the options listed above.